Good afternoon and welcome to this panel, Business and Human Rights, Modern Slavery and Other Compliance Issues in the Global Supply Chain. Bonjour et bienvenue à ce panel, Entreprises et droits de la personne, esclavage moderne et autres problèmes de conformité dans les chaînes d'approvisionnement mondiales. I'm Una Fitzgerald, President of the International Law Association of Canada, ILA Canada, and Senior Fellow with the Human Rights Research and Education Center of the University of Ottawa, or HREC. Before we start, in keeping with Indigenous protocol and building respectful relationships between Indigenous and non-Indigenous peoples of Canada, let me begin by acknowledging the traditional territories of the Indigenous peoples. We are meeting virtually across Canada and beyond, so I would like to acknowledge that the Indigenous peoples are the original occupiers, traditional stewards, and inherent protectors of the lands and waters called Canada today. Nous sommes reconnaissants de vivre, d'apprendre de cette terre et d'en profiter, et nous nous engageons à la décolonisation dans nos vies personnelles, nos entreprises, nos organisations, nos écoles et dans nos communautés. Les engagements que nous prenons dans cette reconnaissance de terre doivent être activement poursuivis et s'accompagnent de la conviction que la décolonisation commence par la réconciliation avec tous les peuples autochtones, y compris les Premières Nations, les Inuits et les Métis. Pour que la réconciliation soit couronnée de succès, nous devons continuer d'approfondir les façons dont nous écoutons les peuples autochtones en tirant des leçons et les soutenant en ce qui concerne leur résilience, leur résistance et leur autodétermination. This panel on business and human rights is a partnership between the International Law Association of Canada and the Human Rights Research and Education Center of the University of Ottawa. ILA Canada is the Canadian branch of the International Law Association based in London, UK, and founded in Brussels in 1873. With over 4,500 members worldwide, our collective objective is to promote the study, clarification, and development of international law, both public and private, and the furtherance of international understanding and respect for international law. ILA Canada serves the Canadian international law community, including legal scholars, practitioners, students, and policymakers by organizing workshops, conferences, and research on a wide range of international law topics. Le Centre de recherche et d'enseignement sur les droits de la personne de l'Université d'Ottawa, CREDP ou HREC, rassemble éducateurs, chercheurs et étudiants de toutes disciplines en raison de la nécessité d'aborder les questions des droits de la personne dans une perspective multidisciplinaire et interdisciplinaire. So, Bill S-211, an act to enact the Fighting Against Forced Labor and Child Labor in Supply Chains Act and to amend the Customs Tariff, came into force January the 1st, 2024, creating new prohibitions and reporting obligations applicable to Canadian businesses engaged in international trade and investment. This legislation is likely to have an impact on over 1,600 companies listed on the Toronto Stock Exchange, over 17,000 Canadian businesses with over 250 employees, and over 175,000 Canadian businesses trading goods internationally. With the first reporting deadline of May 1st, 2024 approaching, businesses are looking for legal guidance on Bill S-211 compliance, supply chain ethics, supply chain audits, human rights impact assessments, and review of their internal compliance policies and standard operating procedures. Today, a diverse expert group of legal practitioners, regulators, and academic commentators will explain the new requirements and consider how they fit into evolving corporate governance, risk management, and human rights due diligence practices in transnational business. We have 9 amazing panelists today, organized into 2 panels. The first is S-211, what is it and what does it mean for Canadian corporations, with 5 speakers. And the second is, what is the broader context and what might the future hold for business and human rights, with 4 speakers. Speakers will each have 10 minutes to present, and at the end of each panel, there will be a question period. Please use the Q&A function to send us your questions in advance of the question period. So with that, let me we'll begin the first panel on what is S211. And our first speaker is Sherry Meyerhofer. She's going to provide an overview of the operations of the Canadian Ombudsman for resource extraction. And she'll talk about recent investigations into complaints about Canadian companies about forced labor in the global supply chains. Sherry Meyerhofer is a Canadian lawyer with 17 years experience in the upstream oil and gas industry and 13 years experience in international governance, rule of law, and human rights. She's worked in Bhutan, Bolivia, Cuba, China, India, Jamaica, Myanmar, Nepal, Russia, and the US. Ms. Meyerhofer has a Juris Doctor from the University of Saskatchewan and is a graduate of the Harvard Kennedy School with a Master's in Public Administration and Certificate in Management, Leadership, and Decision Sciences. Sherry was appointed as Canada's first Ombudsman for Responsible Enterprise. Sorry, I said core incorrectly. Responsible Enterprise, broader than extractive industry, on April the 8th, 2019, and established the Office of the Ombudsperson at the beginning of May 2019. So with that, over to you, Sherry.
Thank you very much, Una. I want to thank the International Law Association of Canada and the Human Rights Research and Education Centre for the invitation to participate in this important discussion on forced labor and global supply chains. And a special thank you to you, Una, for bringing this distinguished group of panelists together. It's definitely an honor to be among them. So for those unfamiliar with the Canadian Ombudsperson for Responsible Enterprise, or the CORE as I'm going to refer to it in short, after decades of pressure from civil society, in 2018, the Government of Canada announced the establishment of an independent office to resolve disputes arising from the operations of mining, oil and gas, and garment companies that operate outside of Canada, and also to provide remedy for those harmed by such operations. The CORE opened its doors in May of 2019, and as of December 31st, 2023, the last time we published our quarterly report, has 21 active complaints at various stages of our dispute resolution mechanism. 13 of these complaints concerned forced labor in the global supply chains of Canadian garment and mining companies. The CORE is a key component of Canada's Responsible Business Conduct, or RBC, for short, strategy. As part of our mandate, we advise Canadian companies working abroad in our three sectors on human rights and RBC. The definition of Canadian company in my order in council is any company incorporated or otherwise formed in Canada, and any entity directly or indirectly controlled by that company. Accordingly, in line with the United Nations Guiding Principles on Business and Human Rights, and I'll refer to that as the UNGPs from here on, for the CORE, Canadian company includes the entirety of a company's supply chain, its contractors, subcontractors, and anyone with whom those contractors and subcontractors have business relationships. As a state-based non-judicial grievance mechanism, the CORE can offer facilitation and mediation between the parties if they both agree. I can also decide to launch an investigation to gather information either through joint fact-finding or independent fact-finding. To date, the CORE has launched 9 investigations using independent fact-finding, all of which relate to forced labor in the global supply chains of Canadian companies. The initial assessment reports for these complaints were published on our website in the last 6 months of 2023, and the final report of one of these investigations will be published soon, and I encourage you to keep your eye on our website. Another important component of our mandate is to provide recommendations to companies. These include recommendations to provide remedies for harms to individuals, organizations, or communities arising from their activities, such as financial compensation or apologies. It also includes recommendations to develop or improve corporate human rights policies and practices. As well, the CORE can make recommendations to the Minister of International Trade, including the withdrawal of existing and refusal to provide future trade services, and the refusal to provide future government funding, including EDC funding. Our recommendations are published on our website, a website that is accessible to governments, communities, organizations, and investors. So that concludes my very high-level outline of the Corps' mandate and complaint process. I'm happy to provide more details in the Q&A. What I want to talk about now is the engagement of companies in the Corps' complaint process. It is important to note that participation in the Corps' complaint process is voluntary. That is, we do not have the power to compel documents or testimony. Within this context, the engagement of Canadian companies in the Corps' complaint process has been varied. Some have fully participated in the process, others have refused to participate or meet, and some have failed to respond at all. Companies that have fully participated early in the Corps' complaint process have benefited by avoiding first publication of an initial assessment report and second, avoiding the launching of an investigation. Of note is the fact that early participation led to one complaint on forced labor to be withdrawn by the complainant due to the complainant receiving a satisfactory response or remedy from that company. So clearly the ultimate benefit for both parties as well as in the public interest. The publication of initial assessment reports launching investigations into allegations of forced labor has motivated some companies to reconsider their non-participation and engage in alternative dispute resolution processes with the complainants after the publication. And we hope these ADR processes will lead to favorable outcomes for the parties and dispense with the need for the investigations announced. The impact of publication on compliance with or cooperation of some companies in the Corps' complaint process appears to be linked, at least in part, to reputation. Reputation, not only with respect to consumers, but with governments and investors. So with respect to governments, as we all know, supply chains across all sectors are being subjected to greater scrutiny. In fact, more and more countries are shifting towards mandatory human rights and environmental due diligence legislation, or HREDD. For example, France, the UK, Australia, Norway, the Netherlands, and the EU. In Canada, we see focus towards stronger reporting requirements, such as Una mentioned, and what is the focus of this panel, the Modern Slavery Act, but also CUSMA, which was a part of the panel, the import ban on goods or customs tariffs related to forced labor. And I just also want to mention the 2021 mandate letters of various Canadian cabinet ministers with a request from the Prime Minister to look at introducing HREDD legislation. Other panelists will speak to these in more detail, and I look forward to their assessment and perhaps adding mine during the Q&A. With respect to investors, there's a growing focus by investors on human rights compliance, including requirements for companies to conduct human rights and environmental due diligence assessments. It has simply become too costly and too risky for them to invest in projects where human rights due diligence has not been done. If a company wants to receive financing, it is going to have to demonstrate its compliance to HREDD with or without government legislation in place. All that to say, within the context of an evolving business and human rights landscape in Canada and the world, the Corps' mandate, particularly its requirement to publish all reports, has demonstrated some ability to influence corporate behavior and address allegations of human rights abuses. However, the fact that some companies have chosen not to respond or participate demonstrates that there's a need to strengthen the Corps' mandate. To this end, the Corps commissioned and recently published 2 papers which assess the Corps' independence and potential effectiveness vis-a-vis the UNGPs and the Venice Principles. These papers make a number of recommendations to strengthen the Corps, including the recommendation to provide us with the powers to compel documents and testimony, and I encourage you to check out these papers on our website. I'd also note in closing that in addition to strengthening the Corps, there is also a better need to coordinate the work of our office with Canada's other business and human rights initiative, including the Modern Slavery Act, which I believe we would be able to use and will be helpful for us to refer to when we're making recommendations to the minister, because there are penalties under that legislation to companies of a certain size. And so I look forward to the comments from the other panelists here today. And that concludes my remarks, and I want to thank you for your time and for your attention.
Thank you so much, Sherry, for that great introduction to the Corps. And so now we'll turn to Laurel Johnson, who is going to speak about, she's going to also provide an overview of S211 from the perspective of, as a Justice Department lawyer. She's going to talk about the legislation and the new requirements. Laurel is the head of the Legal Services Unit at Public Safety Canada. Prior to this, she was the head of the National Security Litigation and Advisory Group, which is the legal services unit at the CSIS, the Canadian Security Intelligence Establishment Services, sorry. And before that, at Correctional Service of Canada. She started her career in private practice representing employers before making the move to Justice Canada 22 years ago. And I had the pleasure of working with her some years ago at National Defence. So it's a delight to see you again, Laurel. Over to you to tell us all about the new legislation.
Thanks, Una. And thanks, Sherry, for the broader context, setting the scene a little bit about other issues and developments in this space. So like every good lawyer, I will also kick off with a caveat, which I am not going to be sharing solicitor-client privileged information today. And these are my views and opinions that get expressed not on behalf of Public Safety Canada nor Justice Canada. So I'm going to start with some tombstone data. Bill S-211 was introduced in December 2021 by an independent senator, Julie Nivelle-Deschênes. Et aussi, j'aimerais noter qu'aujourd'hui, c'est le jour de la francophonie. Alors, I'm proud to be bilingual, although my presentation is in English today. So the bill introduced May 2021, received royal assent May 11th, 2023. And statistically, there are far fewer bills introduced by senators who receive royal assent. So that alone is noteworthy in and of itself for this bill. The bill is short, 13 pages, but on the assumption that you have worked your way through the bill already, or you will do so in the near future, it's dense. You can see that the requirements that this short bill, it packs a powerful punch. So it establishes a standalone statute, which is the act to enact fighting against forced labor and child labor in the Supply Chains Act. It amends the Customs Act, as Una mentioned earlier. It came into force just this January 1st, 2024. And the first reporting deadline is this May 31st, 2024, for what the implicated entities and government institutions have accomplished in this space in their past financial year. And then next September, the Public Safety Minister will have to table the first annual report in Parliament. So this is a tremendously important year as this statute comes into effect. And as you will see, there are many public-facing elements of this legislation. So the Minister of Public Safety and Emergency Preparedness Canada, Dominic Leblanc, he is the responsible minister for this legislation. The Department of Public Safety Canada is supporting the minister, has created a website that's available. If you Google public safety forced labor, you will land on the website that's been created. Public safety will be receiving reports and establishing the registry to publish reports. Justice Canada and our legal service unit, we support the client providing legal advice on this bill. CBSA is obviously implicated, the Canadian Border Services Agency enforcing the Customs Act. And all of this in the much broader context of international commitments, international leadership, a global economy, interconnectedness across the global economy and the web of the supply chain. So what is this act doing? The purpose is identified in Section 3, which is stated to impose reporting obligations to implement Canada's international commitment to contribute to the fight against forced labor and child labor. But when you work your way through the provisions of the statute, you can see that it's more than just imposing reporting obligations, because it is fundamentally about what are you reporting on. So it's imposing a statutory obligation for taking measures to prevent and mitigate the risk that the institutions covered by the Act or their supply chain is tainted by forced labor or child labor. It imposes public reporting on the implicated organizations, as well as on the Minister of Public Safety. It establishes an inspection regime or a verification regime. It also imposes penalties, and it authorizes the minister to compel information or compel action. Like most statutes, the definition section is found in Section 2. It defines child labor. It defines forced labor. It defines entity who is covered by the Act, and I'll come back to that in a moment. And then for the purposes of government institutions also covered by this legislation, it cross-references to the Access to Information Act, which is, and to the head of government institutions as defined by the Access to Information Act, which is helpful since that act's been in force since 1983. There's nothing new there. The entities, Una at the start gave some statistics on who is expected to be picked up by the statute. So the definition starts out broad and then gets limited to a certain size, or entities can be defined in regulations. So by broad, I mean it covers corporations, trusts, partnerships, unincorporated corporations, and then there's a more specific checklist that establishes that there's a Canadian nexus. So there's a place of business in Canada, or they do business in Canada, or they have assets in Canada. And then 2 additional conditions that specify a certain size, which is based on at least 20 million in assets or 40 million in revenue, and or employing an average of at least 250 employees. So the question then for entities is, am I an entity falling within those definitions that is producing, selling, or distributing goods in Canada or elsewhere, or importing goods into Canada produced elsewhere, or do I control an entity that's doing any of those things? And for government institutions, it's, am I producing, purchasing, or distributing goods in Canada or elsewhere? So again, a broad, it's capturing a wide variety of organizations. The reporting details for both government institutions and the defined entities are the same. It's looking for reporting on the risks that you have assessed, what you're doing to eliminate these risks, how you are assessing the effectiveness of your efforts, which is a very interesting learning loop. What policies have you put in place? What due diligence have you exercised? What training have you provided to employees? Details about your structure, your activities, the supply chains that you use. And then also interestingly, measures to remediate the loss of income to the most vulnerable families who are impacted or that result from the measures that you have taken to eliminate the use of forced labor or child labor in your activities and your supply chains. These reports can be, this first year is the most heavy lift in terms of producing a report. Reports can be revised with subsequent years, and reports can be joint with other entities. For example, if it's an entity that has multiple corporations within, they have to be approved by the governing body of the entity, and a member of the governing board must attest, or multiple members must attest. So there's a personal link there, And then, as I mentioned, the entities and the government institutions themselves have to publish these reports. For administration, this is an act. We hear sometimes about statutes being toothless tigers. This act does include an administration and an enforcement regime. The Minister of Public Safety can designate classes of persons or persons to administer and effect the act for verification purposes. Warrants can be obtained to enter premises. Documents can be accessed. Computers can be required to be used. Reports required to be produced. They can limit access to spaces, prohibit access to spaces, remove anything, and have the authority to obtain warrants to access dwelling houses. For example, if businesses are also operating out of what is a dwelling house, with approval from a justice of the peace, they can obtain warrants. So I will wrap this up by mentioning as well, this act includes summary conviction offenses, fines up to $250,000, and there's a 5-year review built into the statute. So again, like businesses who are in a perpetual learning cycle for the work that they're doing in this space, so too for this legislation, Parliament will review in 5 years for any necessary amendments. Thank you, Una.
Thanks so much, Laurel, for that great walk through the legislation. That's a great lead in to our next speaker, who is Jacob Mantle. Jacob is going to talk about Canada's import ban on goods produced by forced labor and the customs compliance issues arising both at the border and beyond the border. Jacob Mantle is in private practice. His practice focuses on cross-border regulatory matters, including customs compliance, economic sanctions, and anti-dumping and countervailing duty enforcement. He's a certified customs specialist with extensive experience helping clients navigate audits and enforcement actions undertaken by the Canada Border Services Agency, and to resolve tariff classification, origin, and valuation issues. He regularly appears before the Canada Border Services Agency, Canadian International Trade Tribunal, and the Federal Court on Cross-Border Trade Issues. So over to you, Jacob.
Thank you, Una. It's a pleasure to be here. I will just I have a few slides that I'm going to refer to in my presentation, so I'll turn those on, and maybe you could tell me, Una, if you can see them properly.
Yes, I think I'm seeing your slide notes still. Yep,
how's that?
Perfect.
Okay, excellent. Well, once again, thank you for having me, and welcome everyone to this great panel on an emerging topic in international law. My name is Jacob Mantle. I am in private practice, and one of the things I focus on is customs and importation issues. So what I want to talk about today is the customs importation ban. And the first thing I always have to tell people is what it's not, because there has been a lot of discussion about Bill S-211, or the Modern Slavery Act, as it's sometimes referred to, and that's not what I'm talking about. Although the Modern Slavery Act made some changes to some of the customs law, these are fundamentally two separate things. And so that's why I always have to say the customs importation ban, that's a separate issue from the reporting requirement that's been discussed thus far. And what I love talking about this issue so much is this is really where the rubber hits the road for private businesses in Canada who are doing those things we described, whether that's importing, distributing, or selling goods, because this is about what happens to goods that may be tainted by forced labor somewhere in the supply chain. So this is not about writing a report. This is about what do I do with my shipment of agricultural products, my shipment of textile goods, my shipment of solar modules that I might have an issue with in Canada, and maybe they're at the port, in Montreal, or maybe they're already on store shelves. And how do we deal with that under Canada's customs law? And it might surprise you to know that While there has been a lot of discussion about Bill S-211 reporting, the import prohibition actually significantly predates any of this discussion and then was actually implemented into Canadian law during the renegotiation of the NAFTA or the USMCA, CUSMA, or TMEC, depending on which country you're from. So in fact, we have had an import ban on the books in Canada for goods produced in whole or in part by forced labor since 2020. Now, the Modern Slavery Act itself, as we said in 211, did make some adjustments to the Customs Tariff, in particular the definitions around what constitutes forced labor and child labor, and arguably sort of expanded the type of goods that might be captured by those prohibitions. So I want to talk about what happens at the border, what happens after the border, and who are the players involved here. And when we're talking about customs law, it's one of those great old historical acts, that dates to just after the founding of Canada and has been around for, over 150 years now. And so it's one of those great old acts with lots of interesting powers in it, lots of interesting powers with respect to persons, lots of interesting powers with respect to products or goods, what we would call in law sort of in rem powers. And so there's actually a ton of heavy hammer powers that the CBSA, which is the Canada Border Services Agency, has both at the border and then after the border, once goods have entered Canada. And the CBSA is really the primary government agency who's responsible for implementing and enforcing the customs importation ban, which is, again, separate from the reporting requirement that public safety is handling. So I've listed for you sort of top powers that the CBSA has at the border and beyond, which of course is, you might imagine, to stop goods at the border and examine them to see if they have been tainted by forced labor, to seize goods, but not only goods, evidence. So if their companies have records or other evidence that the CBSA determines may be useful to make a determination of whether these goods are tainted with forced labor, they can seek evidence. And of course, if they have determined that there is a problem with the goods, then some other powers may come into play, which is to, as you can see there, destroy or dispose of goods. So that may be requiring somebody to have those goods exported from Canada. An administrative ascertained forfeiture there, which is sort of a demand for payment rather than a seizure. And that would be when a seizure is not practical or not possible. So think about if I have a good that's already installed all across the country. There's no way that I could reasonably go to individual consumers and seize that good, even though it may be tainted with forced labor. So a payment or a penalty can be imposed instead. And then, of course, there are civil penalties. And actually, under the Customs Act, there are criminal sanctions. So there are imprisonment penalties with respect to illegally imported goods. And one thing I want to pause here and just highlight for everyone about the importation ban is the language of the description of child labor and forced labor itself. And if you recall from the definition, and you can go back and check it in the Customs Tariff, it refers to wholly or in part. And this is an important factor to keep in mind, because that means under customs law, there is no de minimis level of forced labor that is permissible in imported goods. So if you are importing a complex machine and you have one component of that machine that may be tainted by forced labor, that can cause a problem for the entire machine. And I'll give you an example of that at the end of our presentation. So while the CBSA and the government have all of these heavy-handed hammer powers under the Customs Act and the Customs Tariff, in practice, what we've seen is pretty limited enforcement. And according to publicly reported cases, there has been only one shipment of goods that has been seized under suspicion of forced labor, which, as you can see from the Globe and Mail reporting, was then later released to the importer. Now, there have been rumors, of course, in the trade and legal communities about other actions that the CBSA has taken. But so far, the CBSA, as opposed to other customs entities, such as the United States Customs and Border Protection Agency, they don't publish any statistics publicly about their activities with respect to the forced labor ban. So we don't know exactly all of the enforcement action that the CBSA has taken, but as compared to other jurisdictions, I can tell you it's very limited. Now, is this changing? The information and the guidance we're receiving from CBSA to the trade community is that enforcement will start to pick up. And I think this is in part because of S211 and the CBSA's use of the information that may be supplied to guide their enforcement actions. So new guidance is coming, according to the CBSA, and the CBSA provides that to the importing community by way of policy statements or departmental memorandums, as they're called. And as you can see here, we have had one on the books since the beginning of 2022 on the import ban. And it has been under review for over 2 years now. So the CBSA is certainly not moving with any great speed when it comes to updating this guidance, but as we understand, new guidance will be provided. And in fact, a new draft of the CBSA's guidance has been published and has been circulating since December of 2023, which gives us a little bit more understanding of how the CBSA may approach issues at the border or audits after the border with respect to forced labor. And so I've put on the slide what the CBSA has said it will do in terms of forced labor issues and what its sources of information will be. So the first will be information that the government itself collects, including from the CBSA or Employment and Social Development Canada. It may also accept private complaints. You have always been able to make complaints respecting illegal goods or illegal importations, so that's not new, but they will be doing that. And then other information. And when I see that, that makes me think other information that may be shared with other law enforcement agencies or customs agencies around the world. So it's probably no surprise that the US customs agencies speak with the Canadian customs agencies and there's sharing of information there. When there is a problem at the border, there will be a detention. There will be a request for information from the CBSA to the importer. And then there will be a determination by the CBSA of whether those goods are tainted by forced labor and therefore prohibited. There are a lot of outstanding questions. Happy to get into some of those in the question and answer about how this may happen in practice. What are the legal burdens of proof? What evidence will be satisfactory to the CBSA and what the legal standards are. But I want to end just in the last few seconds I have here with a recent example of how this might play out in the real world. And this is just from February of 2024 in the news where VW internally discovered a potential issue with a component of its sort of higher end cars. So you can see there Porsches, Bentleys, and Audis. And they discovered the potential for a component in the car that may have been produced in a factory in China that had allegations of forced labor. Now, these cars were already at the ports. So the question is, what does VW do now that it knows it may have an issue with products that are already in North America? And so this is a very real world problem that companies are trying to build their compliance around and trying to determine how do we make sure that our supply chain is free of forced labor and what do we do when we have issues? So I'll stop there and I look forward to any questions you might have.
Thank you so much for that, Jacob. Very interesting presentation. We're going to hear from another practitioner right now, and that is Sean Stevenson. Sean is going to talk about business responses to human rights reporting and investigations in Canada. Sean Stevenson is counsel with Dentons Canada, LLP, where he is a leader in the International Trade Group. Sean is the current chair of the Canadian Bar Association section of international law, and he leads its working group on modern slavery. In the business and human rights and ESG space, he has advised clients on some of the most noteworthy issues in Canada. This has included advising several clients throughout the development of the Fighting Against Forced Labor and Child Labor in Supply Chains Act. So with that, over to you, Sean.
Thank you, Una. It's a pleasure to be here and a pleasure to speak again at the Human Rights Research and Education Center. I have to note that when I was a student, I was a fellow at the center, so it's good to be back. I'm going to talk about business responses to the reporting legislation and to CORE. on the reporting legislation, I'm going to sort of I have 4 key points to make. One, there's still uncertainty in the interpretation of the legislation, and namely on threshold issues, and we're still seeing that, even though we are very close to the reporting deadline. 2, there's what you're going to see when we start opening up all of these reports, in June, is really a range of reports and a range of details and a range of how companies have actually approached the legislation. The third point I want to make is that we are seeing significant measures being taken in response to the reporting legislation. And then the fourth point is I want to highlight some success stories that we're seeing. We're seeing companies take really significant actions that are actually having very positive impacts throughout the world. So, this legislation does matter. Legislation like this that has sort of proliferated around the globe in the last 10 years does matter, and it does have real world impacts and effects. So first off, on the sort of the uncertainties and the challenges that businesses are facing, and these are really on more technical points of the legislation. The legislation was passed in May of 2023. Throughout the summer of 2023, once the legislation had been passed, and we knew the legislation was going to pass, there was discussions about passing the legislation in December 2022. They held off passing the legislation, actually, because that would mean the reporting deadlines would kick in May 2023. So they didn't pass it. They wanted to give people a little bit more time. But what essentially happened was the legislation was passed, and then businesses got no subsequent guidance on some of the key issues that they were looking at. So throughout the summer of 2023, I know many of us were making submissions to public safety, and we weren't getting responses back. Guidance was, to public safety's credit, published in December, and I think we've just had an updated version of that guidance. But there's still questions that linger there, and frankly, out in the market, we are still seeing a divergent ways of interpreting the legislation, particularly on who needs to report, key threshold or technical issues about the act. So that is still out there. Those uncertainties have not yet been fully addressed, and is something that we want to see being addressed. We want to have a more open dialogue with public safety. These are all companies that frankly are the good ones. They're wanting to report if they need to report, and they're just trying to figure out what we need to do. So that's sort of point one. There is uncertainty out there. Point 2, we are seeing a range of responses to the legislation, and generally speaking, I say that this is really a range that goes from folks who look at this as solely a compliance obligation. If you're asking me to do a report, I will do the report, but I don't want to put a whole lot of work into it, so I will do the bare minimum. To the other side, or the flip side of what I call ESG superstars, who put incredible amounts of work into their reports and have, generally speaking, really significant compliance programs to back up what they're putting into these reports. This is going to depend on a couple of different issues. One, are you reporting already in another jurisdiction? If you're reporting in Australia, or if you're reporting in the UK, you already have a base to work off of for your Canadian report. The Canadian report is a little bit more exacting, but you already have something there, so you're not starting from scratch. 2, if you're a public company, this obviously will have different types of ramifications. It also depends on how you want to use the report. A lot of companies are going to use this report, frankly, as a marketing tool, to demonstrate the significant and beneficial actions that they're taking. And I think, companies that take those actions, that have, really great compliance programs, should be out there, and they should be saying, look at all the great work we're actually doing in this space to ensure that our supply chains are free of any child or forced labor. And then 2, on the other side, like I said, you have sort of compliance-focused companies, companies who say, I view my risk as very minimal in these types of areas, and will meet the letter of the law, but I don't want to go a whole lot further. So when we open the reports, we're seeing this already. You're going to see a sort of a range of reports from those where you look at and you say, wow, this company is incredible. They're doing incredible things in the area. Significant compliance focus on these types of issues from a trade perspective, from a general due diligence perspective, or just more broadly from commitments they've made on a voluntary basis through the UN mechanisms or others. I guess that sort of segues into what we are seeing in the market in terms of actual measures that are being proliferated. We're seeing a lot of companies update or adopt codes of conduct, supplier codes of conduct, contractual provisions, that deal with forced labor. Particularly as segues well from what Jacob was saying. There are in Canada at least a real trade issue here. So, how do you protect yourselves from that? Well, you can protect yourself contractually to the extent your goods are stopped at the border, delayed, or potentially needed to be exported outside of Canada. That can cause significant commercial issues. So dealing with it on a contractual basis is something that most companies are looking at, or at least many companies that we're working with are looking at. And that can range from simple reps and warranties down to a myriad of contractual sort of terms and references. That being said, what we are also seeing is contractual terms are becoming very market. Probably a year or two ago, if you were to add a rep and warranty into a contract vis-a-vis forced labor or child labor, you would probably get a fairly weird look from your colleagues across the table. Now, when you say those things, there's essentially no blinking and saying, we know why you're doing this. We're seeing, it's a reporting obligation. It is something that we are all having to take into account. So, market terms, generally speaking, around these, forced and child labor issues are becoming, commonplace in Canada and commonplace, across the world. When we deal with folks in the United States, still maybe not as common, but certainly they've, from a trade perspective, well ahead of where we are in Canada. And then we're on the ESG superstar sort of stream. We are seeing that the companies really taking this to heart. I would say, companies that are using these types of frameworks to actually grow their businesses. Once you have a fundamentally great understanding of your supply chain, it gives you so much more knowledge and leverage into, how you procure goods, where you're procuring goods, and really knowledge about the risks, not only for modern slavery and child labor, but risks about, environmental disasters, sanctions, AML, corruption, can really, push your procurement department into a better place. So we're actually seeing companies benefit, have some, positive growth in their businesses from engaging in these types of detailed knowledge about their supply chain. Last, I'm going to highlight just some success stories. I've been amazed at how certain companies have gone about this. I was dealing with a client last week who is leveraging their significant purchasing powers to reduce the number of hours workers at a certain supplier need to work while being paid the same amount of money. They just thought, we can do this for these folks. So we're seeing real world benefits when these measures are being taken. One, I guess, final note. So that's on reporting. One final note vis-a-vis the core investigations. It's something that we're all looking at with significant interest and intrigue. Similar to the points that Jacob made about vis-a-vis the CBSA. The question that we frequently get is, what type of diligence is enough? What type of diligence is reasonable for us to be taking? So that if somebody does make an allegation, we can put up these, we can show our compliance programs and say, look, this is standard, this is market. We've taken significant efforts in these areas. Further guidance on that, I think, would be appreciated. We have looked at some of the initial reports, and some of the initial reports, even for companies that have significant compliance programs, look like the Corps might investigate anyways, or even if you have a significant compliance mechanism, there might not be a way to stop a Corps investigation. So further guidance on that would be appreciated. With that, I'm happy to stop here and answer any questions in the question period.
Thanks so much for that, Sean. And it's encouraging to hear how these new requirements can actually be turned into successful business strategies. Our last speaker on this panel is Professor Jennifer Quaid. She's going to talk about the plausible scope of the Act and the likely effectiveness of the entity liability provisions as compared to existing forms of organizational criminal liability. Dr. Jennifer Quaid is an associate professor and vice dean research in the civil law section of the University of Ottawa's Faculty of Law, where she teaches criminal law, competition law, and business law. She is a leading scholar and expert on organizational criminal liability. So over to you, Jennifer. Thank you.
Thank you, Una. Hello to everyone on this session, and thank you for attending. It's really very interesting, even as panelists, to listen to everyone assembled here. This kind of legislation is actually, I think, as Laurel said, it's short but dense, and therefore you have to spend some time working through it. So I think that having all the different perspectives of people is really, really important. And so I am just taking a very small slice, and I'm happy to answer questions that go a little bit beyond this, but we have some overlap, especially with the previous two speakers coming from the business angle. I wanted to talk a little bit about the plausible scope of the Act. I know Laurel has done an excellent job of sort of explaining and going through the various pieces of the Act. I want to take a sort of second cut at that, if I may, just to identify some things that caught my eye, which may or may not end up being problems, but which at least prima facie raise some questions. This is an act that is intended to apply both to government institutions and to entities. And as soon as I read that word, I'm like, what does that mean? Because we already have a definition in the criminal code that was added in 2003 as part of the amendments that followed on from the Westray disaster. And so I was a little bit interested to know, well, what are we doing here? And although it's similar, it's different. And similarly with government institutions, there are some overlap, but not perfect. And so one of the questions that I have in my head is, maybe as things evolve and there is some room for regulations, there might be some questions about how these provisions might work with the general accountability frameworks that we've developed for criminal provisions. And I suppose I want to just stop right here and say that this piece of legislation, like several pieces of legislation of late, has decided to use the criminal law as the backstop. A combination of regulatory liability as sort of the base standard, and then some intentional or subjective mens rea type liability for knowing violations of the Act. And I think that just taking a step back as somebody who looks at business regulation more generally and accountability mechanisms, I am always intrigued by the sort of very quick reflex to turn to the criminal law when in fact, if we look at, what's involved, it's not always the most straightforward way of going about things. And it does come with some procedural and other costs. Now, coming back to the plausible scope. So I said to myself, okay, so what's an entity? Who are these entities? Well, they are mostly the same, but not quite the same as what we target in the criminal code. And I think that interestingly enough, what the criminal code targets is municipalities, among other things. And I thought, oh, well, maybe that's in government institution, but it's not. So interestingly enough, when we're talking about supply chain and about procurement, maybe there's going to be another section for that. I realize it's a federal enactment, but it is criminal. Maybe there was a debate about division of powers, which does get tricky when you start talking about business regulation. But it was something that interested me. There is also some scope for an unincorporated organization falling under the entity provisions. And then there's some criteria. And a little bit like we do in the criminal code, there's a sort of basically deemed provision. So if you're on a stock exchange, that's it. You're kind of done. And if you're not on a stock exchange, we have these other factors to establish nexus. I'll be interested to know how easy it is to do that. I know the private practice lawyers talked about there's lots of questions, and I think that's something that although we like the precision of having numbers, I do wonder how some of those calculations will happen, and how easy it's going to be for differently situated businesses to make those assessments, which seem simple because of the numbers, but are not always simple in reality. And I think that brings me to another element that I want to just open the door to and then come back to talking about the scope, is that when you're talking about business regulation, a lot of the time, there's a sense that we can just sort of decree what should be done and it shall be done. And if you take a look at, for example, the UK modern slavery sort of web page, if you will, if you Google modern slavery UK, and there's a similar thing for corruption or fraud. It's called the Serious Fraud Office. These are websites where you go and there's a lot of stuff. There's a lot of information. There's a lot of guidance. There's obviously the repository of all the public documents. In this case, it will ultimately, in Canada, we will have a collection of reports. But what I don't see right now, aside from a very, very short, website based thing, is any information on how to make these assessments. There is a very short thing that says how to prepare a report, and here's some guidance, but I'm sure that the private sector lawyers on this panel know that there's not enough information in that guidance to really make all the determinations. And so one of the things that I think comes out of some of the choices of vocabulary, some of the choices of how we think about the application of this act are going to require guidance to supplement it and to assist companies who want to comply. And I think that's important to keep in mind, that if we leave it vague, or if it becomes an exploratory process where the companies have to make mistakes before they get there, I think that's not helpful. So that's something that came to mind for me. The other sort of weird term that I'll have to say that is this idea of governing body, which is a body or a group with primary responsibility for the governance of the entity. And you think, oh, okay, that's general. It seems pretty applicable, except that in corporate criminal liability, we actually got to a point where we had to define something different than this idea of directing will in mind, because it had become so restrictively interpreted. And what we used was a concept of senior officer. Now, there's lots of criticisms of senior officer, but the material point I want to make here is that the reason that definition was created was to get rid of something called the policy operational divide, which was set down in a case, a maritime law case actually, called the Rhone versus Peter Widener. It's two ships. But in that case, the important thing to remember, and that's what I worry about this definition, is that there was a sense that you could only really look to those who had overall responsibility for the entire firm, and not necessarily people who had operational responsibility in a specific sector. And so the way that the definition of senior officer, and it's been confirmed, with the very small amount of jurisprudence we have, seems to align with this idea that, yes, you can actually have, primary functional responsibility, and that's enough to sort of engage the liability of the entity. Here, I worry that we're going to be looking very, very high up at 30,000 feet, and it's hard to make things stick at that level if that's really what's important. So I worry a little bit about some of these sui generis definitions, at least as far as I'm concerned. Maybe other people know that these definitions are used elsewhere, but they looked fairly new to me. And so flexibility and novelty create uncertainty legally, and that can cut in both directions. So to the extent we're interested in promoting compliance and want to create an environment where complying is not guesswork, I am a little concerned about that. The other thing that struck me, and then I'll just have a few more comments, is there's a focus on production of goods. And I think I understand that there's a materiality and a tangibility to goods. They can be physically in Canada or brought into Canada or imported. I just throw the question out there. People will probably jump all over me, but this was the thought question, which is, why is it only goods? why are we not also talking about forced labor in the context of services? Hear me out. I'm not crazy. In the context of a digital economy where increasingly we have piecework and we have use of labor, particularly in the global south, to help do the tremendous amount of work that is involved with the development of new technologies, including artificial intelligence, where training the algorithm takes human intervention sort of progressively. A lot of that human intervention to train these machines has been outsourced. Things like viewing very graphic images to decide, is this something that passes or doesn't pass the test? This is mentally taxing work. I'm not saying that there is, because I don't know factually, whether there are practices that count as modern slavery under our understanding or child labor, but it's worth asking the question. And so maybe this is a first start, but I would think that limiting to products might not achieve everything we want, because it's one of those dichotomies, products and services. We see it in competition law where sometimes it's hard to decide. Is it a product? Is it a service? What is it? So that's another question that came to my mind. I guess the final point, because I don't want to take too much time, and I know that we want to get to questions, is that we talk a little bit about how much do I have? I'm at the end? Okay, let me just say one last thing. Sorry, it goes fast. We've got a criminal enforcement mechanism. I grant you it's only for compliance. So it's like, have you done these steps? It's not really about blameworthy conduct itself. Like, it's not about, are you tolerating modern slavery? It's, are you doing things that are preventing the proper reporting and transparency about it? But nevertheless, there has to be a police force, there has to be prosecutors, and there has to be investigation techniques that are developed. And one of the things I wonder about is to what extent any thought has been given to how these disclosures might help build the expertise necessary to be able to have an independent ability to look at claims, an independent ability to look at performance measures and their effectiveness. I worry if there's an asymmetry where we can't, we're sort of reliant entirely on the disclosures from companies, because there are those who are very good, but there are those maybe who aren't. And so I think that maybe that we need to think about how those can be used to make the people who are responsible with overseeing this make it work. I'll stop there. Thanks.
Thanks so much for those insights and great questions, Jennifer. Okay, so we're now at the first question period. And I do have one question from the audience that I think is from a number of people that would be good to clarify. It was just about whether the legislation applies to government entities, whether provincial or federal, and whether it would apply to things such as pension plans. So I don't know if anyone wants to answer that. But the other thought is, if any of you have questions that you'd like to ask each other or clarifications you'd like from each other. Would anyone like to deal with the question of whether it applies to things like Canada Pension?
I can jump in there. It does apply to government institutions as defined in the federal FOIA Act, though. So there's limitations as to the institutions that it will apply to. In terms of the Canada Pension Plan, I'm not going to opine on that specifically, but they would have to do the analysis as to whether or not they would fall within that specific definition of government entities, or if not, whether it would be classified properly as an entity under the other provisions.
Anybody else?
Yeah, I'll just add on to what Sean said there, because we have received questions, obviously, from clients that are sort of government or quasi-government. Think of things like crown corporations that may be involved in commercial activities and whether they are captured by those definitions. Obviously, it's a case-by-case basis, but indeed some of these government or crown agencies that operate in the commercial space will need to report.
Thanks for that. There was also, Laurel, did you want to jump in on that or no?
No, that's okay. Crown corporations are an interesting cross-section of beast entity. and institution.
Okay, the other question was about the due diligence in Section 21 of the Act, where it says, unless the accused establishes that they exercise due diligence to prevent its commission of an offense under a 19. Does anyone, I guess that's one of those examples where you would like to see more guidance, Jennifer, but does anyone have thoughts about what that due diligence standard might be?
I don't think it's going to be a standard. I mean, I think it's going to be contextually determined based on the size of the enterprise, the extent of its operations. There's going to be sectoral differences. I noticed in, among the useful links on the Canadian page on forced labor, there are links to standards, international standards. And that's how a lot of companies will work, is they'll look to those standards for the procedures to follow. But I think it's going to take a while till we have, determined exactly what it looks like, and it's a moving target. But I would say that that's the challenge with due diligence, is that some people just say, oh, it's industry practice. Well, what's industry practice? Especially when it's something that is evolving, and historically we don't have a long track record of it. So I don't know if the private practice lawyers are in a position to reveal anything about what companies are thinking about. But I would think that they are looking to sources elsewhere in other regimes that have had this legislation for longer.
I can give one sort of analogous area where due diligence defenses do exist or have existed in other jurisdictions. Anti-corruption, anti-bribery is an example. So the UK Bribery Act has a due diligence defense for issues of corporate corruption and corporate bribery. So that's something, for example, that you could, and there's been jurisprudence on it, there's been guidance on it from the UK government to sort of explain exactly as Jennifer was saying, sort of what the contours of due diligence are or may be in certain industries or in companies of a certain size and for a certain sophistication. So that would be a good place, I would think, to start in looking at what a due diligence defense might look like.
Thanks, that's great. There was another question about whether or not social audits are sufficient to meet due diligence requirements. Do you think, is that, again, a case of whether it depends? It depends on what the audit is or the business? Okay. And then there was a question about whether commercial development of oil, gas, or minerals is equivalent to production extraction of a good. Is it a good at that point? I don't know if that's a question anyone can answer, but it's, I guess, it's the difference between actually having a good that's being imported versus developing a mine or anything. Is that something anyone's looked at, and they have any comments on that?
Sure. So it depends on, what you're specifically, I guess, mining in that case. It could potentially be a good, but you're going to need to look at the very specifics of it. And you're also going to need to look at the entity that is, engaged in that process. I mean, is that entity even a reporting entity under the Act? So you'd have to look at sort of, both aspects of it as to, whether it is a good, but energy resources can be tricky. And frankly, you need to get down into the weeds as to what type of energy resource it actually is to make that sort of determination. But that's certainly something where further guidance would be, I think, welcomed.
Thanks very much, Sean. And thanks to all the panelists for your answers to the questions. I think we'll move to the second panel at this point. We've got 4 speakers, and they're going to be looking at the broader context. What might the future hold for business and human rights? And so let me introduce our first speaker, who is Akinwumi Ogunranti, who's going to speak about comparative and critical perspectives on modern slavery legislation. How is Canada's approach different from Australia? And you'll note the person who asked a question about comparative legislation that we didn't put that question to the last group because we will be discussing it a bit in this group. Dr. Akin Wumi Ogunranti is an assistant professor at the University of Manitoba. His research focuses on business and human rights. Before joining academia, he practiced law in Nigeria and Canada. He was also a compliance associate for a global fintech company for 3 years, focusing on due diligence. Akin is a member of the Association of Certified Anti-Money Laundering Specialists and the Manitoba Law Society. Over to you, Akin.
Thank you so much, Una, and I'm really happy to be here. And I've had presentations earlier, which again, that was me in my presentation. So I'll be discussing in the next couple of minutes about comparative perspectives, right? So we've been talking about the Modern Slavery Act in Canada. So the question is, how do we compare the legislation in Canada with previous legislation in other countries? And my focus here is on Australia. And there have been previous legislation from the UK in 2015. There have been the UK, the California Supply Chain Act in 2010, right? But because of the time, I'll just limit myself to Australia because that's the latest legislative development in 2018. But the question is this: why the comparison? Two things. First, for companies to navigate the regulatory framework, right? And as other presenters alluded to, it's complex, right? So the question is this: would a due diligence report prepared for Australia, would it serve the same purpose in Canada, right? So if we have a company actually preparing a report for the sole purpose of doing business in Australia, would the same report be compliant in Canada? Then the second reason why we do this comparison is that we need to take stock of the emerging legal regime in legislative reporting of this nature, right? So if we know where we're coming from, it's easier to say this is likely where we will be going. Okay, I'll narrow down on two issues, and I'd say these are just high-level discussions because of my time. I know there are other nuances in the legislation. And in reference to Australia, I would also make references to the UK and the California Supply Chain Act as I move on. Now, two things we can notice about the scope of the legislation in Canada. The reporting threshold in previous legislation, it has focused on revenue. Say, for example, in the UK, you have 38 million pounds. A company that makes 38 million pounds would, of course, be obliged to report. In Australia, it's 100 million Australian USD. So, and you focused on the threshold, the revenue threshold. But in Canada, you see that it's different. Now, you're looking at if the company is on the stock market or is registered with SEC. And then you see that even if there's legislation that prescribes that the company should report, then there's an obligation to report. Then the third one is where business has presence in Canada, where business is doing business in Canada, and then satisfy three criteria. Number one is 20 million in assets, 40 million in revenue, and then 250 employees. So you see that in Canada, the threshold is lower. It's encompassing, it's broad. Is that a good thing? Maybe no, maybe yes. Jennifer alluded that, of course, innovation can sometimes be murky, right? So companies would have to navigate this regulatory requirement, especially on the threshold. Then the second scope, which of course stood out to me, was the content of the due diligence report. You see that beyond the training, the risk assessment, the remediation, the ongoing audit, right? Beyond all those in the statement, Canada has a very unique obligation for corporations. So the purpose of the forced labor legislation is, of course, to say to prevent, right, and to assess risk. But compared to other legislation, who, of course, has negative responsibilities, Canada now imposes positive obligations on companies. What do I mean? It means that even where corporations undertake due diligence reports, they conduct the risk assessment. And by virtue of that, some people were excluded, or some people who would have been employed and would have fallen under the forced labor, child labor legislation, or would have been prohibited. Those category of people, when they lose employment in that manner, the law provides that the company must take positive obligation to cushion the effect of loss of employment in that regard. So you see that the debate in the business and human rights about whether companies have a positive obligation is playing out in this legislation, such that companies do not only have the obligation to prevent, they also have the obligation to actually promote human rights. And that's my interpretation of that legislation. So companies now must be wary about that provision that says that you should also provide a cushion in cases where people lose jobs because they would fall under the Forced Labor, Child Labor Act. Now, in previous legislation, I've told you that Canada is leading in terms of the scope. Now, when we look at the enforcement, right? Previous legislation, they've excluded civil remedies. They've excluded criminal remedies, although there's been a conversation about that in the UK about including penalties, but it's not emerged yet. And in Australia, we see that Section 25, subsection 2, expressly excludes criminal sanctions, the ability of a minister or any of its representatives to enter into any dwelling place to make any search, which means that in Australia, the only compliance mechanism is that the minister has a register that he would list compliance companies and and then if your name is not on the list of the register, that means you're not compliant. This is very similar, at least in Australia, it's very similar to the Global Compact and the notion of naming and shaming. But the Australian legislation doesn't really have that teeth to go for corporations. Now, when we look at in Canada, Canada's legislation is the first to provide criminal sanctions for non-compliance. So in cases where companies file misleading statements, in cases where the minister has asked the company to review and they fail to do so, in cases where they don't even comply with the legislation, you find that there are sanctions for it, right? So you see that it's a sanction at the company level, even at the director's level. So the criminal sanction or the regime in Canada provides a stronger accountability regime when compared to previous legislation. Now, the point is this: Canada does not, like in previous legislation, provide a civil remedy, right? So we still have that lacuna of civil remedies in the legislation. Now, I'd conclude with this thought, right? I've compared previous legislation to say that, number one, the scope in Canada is broader, right? And I've said that there is a criminal sanction, and in previous legislation, we do not have that in other countries. But the question I want to leave us with, and I think Penelope will talk more about this, is it enough? Right? So say, for example, in this legislation, we don't have civil remedies, right? You know, previous presenters have talked about the legislation, the interpretation, right? But the question again is this: assuming that we have a lucid interpretation, we have that clear interpretation of the statute, is $250,000 being the penalty for non-compliance? Is it enough? If we are asking companies with 20 million in assets and 40 million in revenue to actually declare and comply. And I say this because I've had discussion in my business and human rights class, and a student raised this question: would the risk of complying not outweigh the risk of complying? Say, for example, a company with 40 million in revenue pays $250,000 for non-compliance, right? So that's nothing, right? So the question is this: we've said these beautiful things about the legislation, but is it enough? The scope of the legislation being just for due diligence for forced labor and child enough, is it enough? Should we be looking at a broader human rights due diligence legislation in Canada? Should we include civil remedies? So those are some of the questions that at least pops up when we're looking at the comparative perspective and looking back and looking ahead. So I'm happy to answer questions during the Q&A section.
Thank you so much for raising those great questions and doing that comparison. All right, our next speaker is, as foreshadowed by Akin, is Penelope Simons, and she's going to talk about some of the problems with S211 and the need for a broader legislation that requires Canadian companies to engage in human rights due diligence with respect to a broad range of human rights and provide some means of enforcement, such as a private cause of action for those harmed. Dr. Penelope Simons is a full professor, Faculty of Law, Common Law Section, and Gordon F. Henderson Chair in Human Rights at the Human Rights Research and Education Center, University of Ottawa. So over to you, Penelope.
Thanks very much, Una. Can you hear me? Okay, yes, good, okay. Yeah, I'm sorry I just was able to join. I haven't heard the previous presentations except for Akinwuni's. So because I was teaching, so I apologize if I repeat anything that anybody else has said. These issues of forced labor and seafood supply chains that have been all over the news. This is really important that we're talking about this, but these are just one example of how Canadian companies have been implicated in human rights violations in their global operations. And it's been an ongoing issue in relation to other sectors like the extractive sector and the garment sector. And so I think Akinwuni's question, is this enough? Is this legislation enough? I think my short answer is going to be no, it's not. But I'm going to tell you why I think that. So first of all, I just wanted to sort of set out Canada's international human rights obligations, which is with respect to business activities that hearken from Canadian territory, is that Canada has an obligation under international law to protect human rights. And what does that mean? That means that it must take steps to prevent private actors from violating human rights. And this includes an obligation to take appropriate legislative and other measures in relation to all activities taking place in whole or in part in Canada's territory and jurisdiction, and that have a direct and reasonably foreseeable impact on the human rights of individuals or groups in other states, including those by corporate entities that are based in Canada's jurisdiction. And where those violations occur, then Canada has an obligation to investigate the allegations, to sanction the actors, and to take appropriate measures to ensure there's an effective remedy for victims through judicial, administrative, and legislative and other appropriate means. Now, turning to the Fighting Against Forced Labor and Child Labor Supply Chains Act, I think, although the intention behind this law is laudable, I think the legislation itself is problematic. And one of the main reasons is that it gives the false hope that there will be action on the part of companies to prevent goods being made or processed with forced labor or child labor. And that those products will not find their way into Canadian markets. So the key thing about this is it's a reporting law, which I'm sure you've already heard. The companies merely have to report annually on the steps they've taken during the previous financial year to prevent or reduce the risk of forced or child labor in any step of the production of goods in Canada or elsewhere. And they have to talk about the company's policies, their due diligence processes, and any measures taken to remediate any forced labor or child labor. And it has to be a public report. And while they can be fined for providing false or misleading information, there's no obligation on companies to actually engage in due diligence to prevent or even eradicate forced or child labor in the supply chains. And there's no consequences if they don't do so. They just need to report on what steps they've taken, if any. And so if a company has no policies on forced or child labor, or it's taken no such steps, it will only need to report on that. If it is only, it's only if the company actually fails to report that it's going to be, or it provides false or misleading information, that it's going to potentially be able to incur this fine. And there's no remedy at all. As Akinwumi pointed out, there's no remedy for victims of corporate human rights abuse to bring a claim against these companies if they have engaged in forced labor or child labor. And so the prescriptions of this bill do not meet Canada's obligation to protect human rights. They do not even meet the prescriptions set out in the Guiding Principles on Business and Human Rights, the United Nations Guiding Principles. And the hope behind this legislation, it's reflexive legislation, is that the act of the reporting is going to incentivize companies and their managers to take action to address these risks in their supply chains. That's going to shame them somehow into actually taking action. And as Akinwumi pointed out, it's modeled on the UK and the Australian modern slavery legislation, even though there are some differences. And those two have both, and I'm going to talk a little bit about that, have proven ineffective to address modern slavery. Studies have shown that both these laws have failed to ensure that companies address and eradicate forced labor in their supply chains. So the Business and Human Rights Resource Centre did a study of 16,000 corporate reports over 5 years under the UK Modern Slavery Act. And they found that transparency, even though it's important, was insufficient to prevent even the worst forms of labor abuse, and that the legislation had failed in its stated intentions. And then another study was done in Australia on the Australian law that looked at a fewer number of reports, but about 102 reports, but of companies from a wide range of industries. And that study found that the majority of companies engaged in superficial reporting and failed to address even the mandatory reporting criteria. Over half of the companies were failing to identify and disclose salient sectoral risks in their operations and supply chains in relation to modern slavery. And less than 30% of companies whose reports were reviewed could demonstrate that they were actually taking some form of action against modern slavery risks that would lift supplier working conditions or tackle root causes. And so this legislation is really wholly inadequate for the task of preventing and addressing forced labor and child labor in Canadian supply chains of Canadian companies. If it's meant to kind of pay lip service to the issue, then it's doing that, I would say. And even when the bill was being discussed in committee, Syria Diva, who was on the Working Group of Business and Human Rights and is now the Special Rapporteur on the Right to Development, in testimony before the Senate, questioned why Canada would use such an outdated and ineffective form of regulation. I'm just going to say a couple of things now about, how much time do I have, Una? A couple minutes?
3.5 minutes.
Okay, I can do it in 3.5, no problem. So as I mentioned, that the human rights implications and environmental implications of transnational corporate conduct has been on the radar of Canada for over 2 decades. And it has continued to be addressed by the Canadian government through policy and this kind of hope and prayer that companies will voluntarily self-regulate, or now through this reporting bill that even only addresses a very narrow set of human rights violations. Now, there is a very good private members bill on human rights and environmental due diligence that was tabled by Peter Julian in March of 2022, Bill C-262, that if enacted into law would impose a duty on companies to avoid causing or contributing to adverse human rights and environmental impacts abroad, within their corporate groups or through their business relationships. And it would also impose liability for harm caused through the failure to comply with those duties, and require companies to actually develop and implement due diligence procedures and engage in ongoing human rights due diligence in relation to their activities and supply chains, and report annually on what they're doing and the measures that they've taken. The other thing that's important about that bill is it would create a private cause of action for those who suffered harm because of the failure of the company to meet its duty to prevent adverse impacts, and another cause of action for certain persons to bring a claim against the company where the company has failed to develop due diligence procedures. Now, this bill hasn't been picked up by the government, but Canada has been the subject of calls by a wide range of international bodies, United Nations treaty bodies, Canadian parliamentary committees, the Inter-American Human Rights Commission, for example, and UN, other UN bodies, to regulate its entities abroad. The EU has just introduced human rights due diligence and environmental due diligence legislation. I haven't had a chance to look at that. I know it has fallen short of expectations, but it's still a step in the right direction. And it is within the mandate letter of the Minister of Labor to introduce legislation that goes broader than forced labor, that applies to more human rights abuses. And we really need something much more effective than this sort of old-fashioned modern slavery reporting bill that we have in place. And I really hope that Canada does what the newspaper said it was going to do the other day. The Globe and Mail reported it was going to do, and put something in place with teeth. Thanks.
Thanks so much, Penelope. That was very interesting, and I think it flows nicely into our next speaker, who is going to talk a little bit more about the global context, and that's Salvador Herencia Carrasco, who's going to talk about challenges to business and human rights, regulatory experiences from abroad. I guess we're all looking for best practices and examples. Salvador Herencia Carrasco is part-time professor, section de droit civil at the University of Ottawa, and a member of the Human Rights Research and Education Center. Over to you, Salvador.
Thank you very much, Una, for the kind invitation, and thank you to International Law Association of Canada and our Human Rights Research and Education Center for hosting this important event. It has been a great privilege to listen to this stellar group of panelists. My name is Salvador. I am a human rights lawyer, and what I would like to talk in this 9.5 minutes that I have left is from a business or from a human rights perspective, the challenges, how I see this different regulatory procedures in the global scales of the business and human rights regime. What I'm going to say now, or what I'm going to present now, is based on my experience supporting indigenous communities and other human rights organizations to litigate cases at the national and international level, mostly in Latin America. After hearing all the presentations and all the debate that has been happening on Australia, Canada, and UK regarding modern slavery and child labor regulations, I only have one word, and this is disappointment. It is disappointing that 11 years after the adoption of the UN Guiding Principles of Business and Human Rights, we need to celebrate regulations, as watered down as they might be, on modern slavery and child labor. This is where the field stands. And this is problematic. That in 2024, regardless if there were or not UN guiding principles, companies have to adopt regulations, or states need to further regulate to prevent slavery and child labor. Does that make sense? So we can talk about whatever sections of reporting or transparency of if there are teeth or there's lack teeth or insufficient teeth, but this is the problem. We're not addressing regulatory, or the states are failing to adopt comprehensive regulations to prevent and address human rights violations, breaches, or impacts, however you may want to call it, in the field of business and human rights. This is the real problem of the situation here, that we are on a rush to the basement. Last week, on Friday, the European Council adopted the Corporate Sustainability Due Diligence Directive after being watered down by political interests. As it stands, and if it's finally approved this year, this directive on due diligence for human rights and the environment would only be applicable to 0.05% of European companies. And I can assure you that these companies most likely already have regulations or practices in place. So this reluctance, or this watered down regulations that we see not only in Canada, but you can see in France with the loi of due diligence regulations, in the Netherlands, Australia, so on, what is causing or is leading is for potential victims, human rights and environmental defenders, to bring cases to court. I mean, I think it is a sign of the current times where we live, where states are failing to fulfill its international legal obligations, and we have to resort to courts to try to fill that gap that states should have done in the first place. For businesses, And for corporate lawyers, this created a challenge because what we're seeing now is that human rights tribunals or constitutional courts are having to incorporate or use that constitutional lens to regulate or to adopt a case law on the field of business and human rights. And this, as Professor Quaid mentioned in the previous panel, creates some sort of uncertainty because whatever a court in Kenya or Nigeria might state about due diligence might be completely different than what a Peruvian, a Brazilian, or a Malaysian court might say on this matter. This creates problem not only for human rights lawyers. What are the standards when we talk about impact of human rights due to corporate activity, but also issues on access to justice, reparations, and judicial review. This creates an uncertainty, so the concept of corporate sustainability becomes more of a punchline rather than a precise concept where we can expect some sort of behavior and outcome and desired outcome. Having said that, there are interesting challenges within courts, and I'm going to focus as a Peruvian lawyer to some Latin American experiences to show how this is slowly trying to frame. We have seen, for example, in the Inter-American Court of Human Rights, which is an international tribunal similar to the European Court of Human Rights with jurisdiction over 22 countries in the Americas, have adopted by case law judicial decisions and standards on, for example, health and safety in the workplace, issues regarding forced labor or servitude, what are the business obligations regarding due diligence, and lately, in a case from late last year or from early this year, in a case of Olivera Fuentes versus Peru, it is perhaps the most advanced judicial decision to engage with the UN, with the second pillar of the UN guiding principles, including but not limited to what does it mean to have a meaningful consultation with stakeholders? What is the review process of companies' due diligence practices and policies? If you're interested, I can talk about a bit more about these cases in the questions and answers or in the chat. But what we see here is the creation of a judicial human rights-based framework to address or to prevent human rights violations perpetrated by corporate activity. So the lack of regulations, where in some cases, some corporations see due diligence as a CSR plus initiative that is voluntary. What we see now are judicial tribunals to continue to engage and to give a specific content and specific teeth that create newer obligations on states and businesses alike. There are many examples, especially, and this is very important, for Canada, where Canada has approximately 70% of the mining projects that are exist in Latin America, 70% are or involve a Canadian company. So these regulations, this is what's happening in the global south. This is an FYI presentation. No, but these are elements that include specific obligations that corporate lawyers advising mining companies operating in Latin America are disregarded. And this negligence or this disregard affects people's lives. For example, yesterday, Bloomberg reported that the Louis Vuitton company that's selling vicuña sweaters for $9,000 at retail price, they pay $200 to the entire community in rural Peru. And this is just one of the little examples that we can see on a daily basis that are showcased, that are being showcased about how the discourse in countries that should be leading the way, in a way, they should be taking notes from what is happening in the global south. What is coming? What is coming is, just yesterday, a Peruvian court declared that a river in the Amazon basin is a subject of rights. Regardless of what we may think or not about that doctrinal approach as nature is a subject of rights, on a personal note, I approve it. We can discuss that in the Q&A if you would like that. But this means that in a way is the people and indigenous peoples are taking courts to fulfill the job that states have failed. In that decision, the court determined that the indigenous community who is affected by Canadian oil companies operating in the Amazon basin are the ones that should control and should monitor the river activity, the commercial activities that happen in the river. And secondly, this Friday morning, the Inter-American Court of Human Rights will deliver its judgment on the case of the La Oroya rural communities versus Peru, which is a case where the court will, among other things, address the issue of environmental due diligence, but also the obligations of corporations on environmental impact assessments, but also in the closure of mining or extractive products. As a disclaimer, the Human Rights Clinic of the Human Rights Research and Education Center intervened in this case. And I think that for all of you, or whoever is interested in environmental matters, environmental justice, this is going to be one of the most important leading cases of the Inter-American Court in this field. To conclude, Una, and to respect my 10 minutes, what we see now is that the lack of will of states to properly regulate business and human rights is not stopping human rights lawyers, indigenous leaders, to seek that regulation and that protection through courts. So one does not clash against the other, but I would love to see that the states actually fulfill their duties along with whatever judicial reviews or judicial cases are being brought to court in this field. Muchas gracias.
Thanks so much, Salvador. And we've sort of expanded the topic of human rights into the impacts on environment, which I know Sarah Seck is going to talk a little bit about too. So I'm pleased to introduce you to our last speaker today, and that is Sarah Seck. She's going to talk about the 2023 updates to the OECD guidelines for multinational enterprises on responsible business conduct, regarding how they confirm the increasing importance of environmental matters in business and human rights compliance. Dr. Sarah Seck is the Yogesh Keddy Chair in Human Rights Law and Director of the Marine and Environmental Law Institute at Dalhousie University's Schulich School of Law, and she's also a board member of the ILA Canada. Over to you, Sarah.
Great. Thank you very much, Una. Thank you to ILA Canada colleagues for setting this up, and thank you to the other panelists. I've learned a lot in this session. This is definitely a nice segue from what we've just heard. I am going to start by speaking about the importance of Canadian businesses and government to wrap their heads around the implications of, in particular, the UN General Assembly endorsement of the right to a clean, healthy, and sustainable environment, the recognition of this right in July 2022. The slides that I'm drawing upon here in part come from work that I've done for the UN Environment Program to develop training materials for businesses on a human rights-based approach to the plastics value chain, in which we use the right to a clean, healthy, and sustainable environment as a framework for understanding possible approaches to solutions for businesses in light of the huge plastics challenge that we face right now. I want to start by noting that of course, most of the talk today has been on labor, and there is a tendency to see environment as something that is quite separate from that. I think Salvador has pointed to some of the linkages, but I want to emphasize those linkages as well. It's simply not enough to be protecting workers and children from sort of forced or child labor. we really need to be ensuring that workers are have and engage in what we might think of as sustainable livelihoods. And so thinking of workers in relation to the environment, workers as part of families, often having children, part of communities, really embedded in their local environments, is a better way to think about engaging with workers than just purely looking at protecting them from forced labor or child labor, for example. And you can do this very much by thinking about the component parts of the right to a clean, healthy, and sustainable environment. So the image that I have up here is one that tries to highlight that a framework for understanding the content of this right can distinguish between the substantive components, where we could think of clean air, safe climate, clean water, healthy ecosystems and biodiversity, healthy and sustainably produced food, and non-toxic places to live, work, and play. And on the other side, the importance of supporting procedural rights. And so substantive rights don't just happen. In order for people to exercise their rights, they need to have, for example, access to information. And this information could and should be provided by businesses about, for example, the toxic substances that might be being used in business operations. Information needs to be provided in ways that people can understand it. They need to have freedom of expression and the ability to protest as needed without being subject to sanction. Included in environmental decision-making and access to justice in the event of harm. And the bottom part highlights the importance of paying particular attention to issues of equity and non-discrimination, so that we understand that some people are innately more vulnerable to environmental harms if we think of children, and other people have been rendered more vulnerable to environmental harms if we pay attention to histories of colonialism that continue their legacies today. So this framework, I think, is really helpful, and it also helps to link again workers with environment, because if we think about workers having access to information about environmental impacts that they can then use to support environmental issues and decision-making in their communities, this can be a very valuable way to realize substantive environmental rights. Now, Canadians might say, well, this is just a UN General Assembly resolution, but I note that, of course, another UN General Assembly resolution on the rights of Indigenous peoples dates from 2007, and while there wasn't a whole lot of attention on one level being paid to it at the time, since the Truth and Reconciliation Commission, the calls to action, there is no doubt that businesses have a responsibility to respect the rights of Indigenous people and the UN Declaration. And this is particularly so if we look at it in light of the guiding principles on business and human rights. So this, I think, is fairly clear, even if it's not always followed. We know that Canada's policy on responsible business conduct abroad speaks to many of these issues. If you look at the history of it, it did not initially say a whole lot about Indigenous rights, but now it very much does. There's no question, again, that Canada's policy endorses respect for the rights of Indigenous peoples. And so I think we should anticipate, hopefully, that there will equally be endorsement of the need for respect for the right to a clean, healthy, and sustainable environment as being very much on the horizon. Now, one other thing that hasn't received much attention today is Canada's OECD national contact point. It is, of course, noted in the strategy. Unfortunately, Canada's engagement with the OECD guidelines and the national contact point has been the subject of a lot of critique over the years. I think Canada has responded slightly to make some changes, but it is nevertheless, I think, compared to OECD national contact points in other countries, at least in some of the leading countries, I think we could say Canada's is still one of the less resourced, weakest, and least trusted, which I think is a huge problem and a huge missed opportunity for us in Canada to have some really serious and important conversations about the relationship between environment, human rights, and other aspects. And that's what I want to sort of focus on. I'll skip that slide for the moment. So why the OECD guidelines and what has happened recently? The OECD guidelines, of course, date from the 1970s. They've gone through a lot of different updates. At a certain point, the idea that adhering states needed to have a national contact point where specific instance complaints could be brought has become a key part of the guidelines. In 2023, the guidelines went through a targeted update. And so they're no longer, they are now have a lengthier title. They are now the OECD Guidelines for Multinational Enterprises on Responsible Business Conduct, which of course mirrors the responsible business conduct language of Canada's new strategy. There are 51 adhering states. Some of them are OECD states. Some of them are non-OECD states. The key expectation is that all business avoid and address negative environmental and social impacts arising from their operations, while contributing positively to sustainable development in every country that a business operates. We do have clear statements both within the OECD RBC guidelines and from Canada's NCP that we should understand these guidelines as applicable within Canada as much as outside of Canada. And I think that's another really important piece of the conversation, is to make sure that we're thinking about responsible business conduct as relevant within Canada as well, because there are a lot of conversations we need to have here too. The guidelines adopt a risk-based due diligence approach that mirror the UN guiding principles with a focus very much on rights holders. And I note that the guidelines note that the expectations are the same for domestic enterprises as for multinational enterprises, and small and medium-sized companies are encouraged to observe the guidelines as much as possible. And there's been an evolution in attention to SMEs in the guidelines over the years. For people who do follow the guidelines, they would be familiar with this image. This is from the 2018 OECD due diligence guidance for responsible business conduct, which shows sort of the cycle that businesses should take for implementing responsible business conduct into policies and management systems, all the way through to the provision of remediation when appropriate. This slide is where I want to spend a little bit of time. I'm at time. Okay, one sentence then. The key point is that the OECD guidelines provide an opportunity to think holistically about the relationship between different chapters. So we tend to think of labor over here and environment over there and human rights somewhere else. But in the work that we did on plastics, for example, we showed how each of the different chapters could contribute to addressing environmental issues, how they were interrelated, and how they all respond in different ways to the right to a clean, healthy, and sustainable environment. So I'll stop there. I just wish Canada and everybody was spending more time thinking about this as a really useful tool to move beyond the siloed attention to labor from environment, which is very problematic. Thank you.
Thanks so much, Sarah. And for bringing insights from more the environmental point of view. And of course, any discussion about sustainability should be including the human rights, labor, environmental dimensions, right? So hopefully the developments in this area of corporate social responsibility will be integrating all of them. We only have about a minute for the second question and answer period, and we've had a number of questions answered already in the chat. So I thought I would just ask, is there a question that anyone in the last panel would like to ask to any of the other panelists? I'll give you that chance first. Or from the other panels, if there's someone who'd like to ask a question. I see Penelope. Yes, go ahead.
Hi, I wouldn't mind Thank you very much, Una. Just asking Laurel Johnson, like what are Canada's plans? Are you allowed to say in terms of supposedly strengthening the legislation, the bill, the Fighting Against Forced Labor Act, and incorporating some teeth to it? I'd be interested to know. And does that include kind of a broader focus on a wider range of human rights and the potential for remedies?
You've nailed it, Penelope. I'm not allowed to say, but I would, I mean, we're giving legal advice. We're wearing our Justice Canada hat. Justice Canada is also the policy holder for criminal law policy. So in addition to different ministers across government having their different portfolios, Justice has the criminal code as part of its responsibility. But you're right, for future plans, we have to look more at this point to politicians than lawyers.
I think you mentioned, Laurel, in your introduction that that the legislation has a review built in, right, in 5 years. So I guess that anticipates this is not a finished matter.
It does, and that's a best practice with legislation. I would suggest that it has, sometimes we see a 3-year review actually, or a 5-year review, where there's a clear signal that Parliament there will be a parliamentary committee struck to review the legislation, consult broadly on how it's been working, room for improvements, etc., and a certain amount of time built in for reporting back on the findings of that.
Can I just ask a quick follow-up, Laurel? Again, within the confines of what you can say, has there been any express, public indication of the lead agency, the lead investigators, and the lead, prosecution service? Is that all going to be federal, like public safety, RCMP, PPSC? I'm just curious, like, right now we're at the stage where we don't have any reports, so no one's done anything wrong yet. But has any thought been given to, like, what's the administrative structure behind this regime? Like, who holds the accountability for this within the government departments? I know Justice has a piece, but I was just wondering if you can say that, or if that's not determined yet.
I genuinely don't know, Jennifer, but I noted with interest something that's somewhat unusual in this legislation, in that it is not a frequent provision, and it's that the Act, and I'm just going to open the section here, specifically says, Section 4, that it's binding on His Majesty in right of Canada or a province. So
yes, I saw that too.
Yes, and there are few statutes that actually say that. That seems to be something that we're seeing more often recently as well. If you did a historical review of legislation, it's unusual for that. And I mean, it goes back to constitutional law and the division of powers. So, and I point that out only from the perspective linking to your question about Crown prosecutors on the provincial level as well. But I genuinely don't know the answer to the question.
Looks like the potential for lots of interesting litigation at some date. That's great. Well, this has been a really fascinating discussion. You've outlined, here we are on the cusp of a kind of a new era with this reporting. But as you've heard from many of the speakers, that this is a long process that we've, I know Penelope has been involved for many years working on these issues, as have others, trying to figure out how do we address these issues of global accountability for conduct by Canadian companies abroad, and how do we ensure that when we go shopping, we're not buying things that have slavery in the supply chain. So they're really complex issues. I'm so grateful to all of you coming forward to participate in this discussion, because we had so many people in the audience interested in it. We had great questions. I know this concerns a lot of people. And I think what we can say is we have to keep watching this space, that it is an area under development. It involves those working for the corporations, those who are constantly challenging the corporations and the civil society. It involves academia, and it certainly involves the regulators trying to figure out what needs to be done. So, and of course, the courts around the world. So thank you so much to everyone for your participation. And I would like to say on behalf of the whole audience here that I'm really grateful to all the excellent speakers we've had. They've provided a lot of useful information. And I really thank the audience for their attention, their probing questions. I could see, you know, in the questions there's often frustration with this very, very complex topic. So please do follow both ILA Canada and HREC on our respective websites and social media for the next events we'll be doing. And you are most welcome to join the exciting and supportive international law community at ILA Canada. And please note that we provide free membership for students. So I thank the partners at ILA Canada and HREC, and I wish everyone a wonderful evening. Thank you so much.
Thank you, Una.